Welcome to today's webinar, Environmental Due Diligence, Be Prepared, hosted by the Maryland Department of Planning, the first in a series of 3 programs that are part of a series we are calling From Due Diligence to Redevelopment. My name is Sylvia Mosser. I am a resource conservation planner with the Maryland Department of Planning. In this series, we will explore how Maryland's brownfields provide a unique opportunity for communities to meet economic development goals, environmental protection, and sustainability goals, and help achieve local comprehensive plan visions and objectives. Maryland's brownfields can also be assets for revitalization, reinvestment, and redevelopment. This webinar series will provide opportunities to learn the essential environmental and statutory requirements for brownfield property transactions from regulatory, legal, and consultant experts, as well as assistance and know-how for redeveloping brownfields from federal, state, and real estate development specialists. This webinar is one of many webinars produced by the Maryland Department of Planning. The department also produces webinars on behalf of the Smart Growth Network on smart growth and planning topics available for viewing at smartgrowth.org. You can also find out about planning initiatives, planning tools, and educational opportunities in Maryland by visiting the Maryland Department of Planning's website at planning.maryland.gov. We are recording this webinar and will be posting it on our website. We encourage you to visit the website and to visit smartgrowth.org, where you can subscribe to our email list to learn about our upcoming webinars. The views expressed by the speakers in this webinar are those of the speakers and not necessarily of the Maryland Department of Planning or the state of Maryland. Viewers of this live event are eligible to receive 1 CM credit from the American Planning Association. To log your AICP credit, visit the American Planning Association's website at planning.org, log into your account, and search for the name of today's event, which is Environmental Due Diligence, Be Prepared. You can also search for event number 924-9766. Our speakers today are Gary White, Jeffrey Harp, and Stephen Luttrell. Gary White is an operation construction manager at Prologi, where he identifies, coordinates, and manages tenant and capital improvement projects and procures permit approvals. He has more than a decade of experience in environmental remediation. Gary previously worked for the New Jersey Department of Environmental Protection, where he approved stormwater and flood hazard area permits and conducted site inspections and technical plan audits. Jeffrey Harp has been with Maryland Department of the Environment's Land Restoration Program since 2004. He manages projects in the Voluntary Cleanup Program, Site Assessment and Remediation Division, and the Federal Assessment and Remediation Division for National Priorities List sites. Stephen Luttrell, a partner at Whiteford, Taylor, Preston, represents clients in matters related to solar and renewable energy, environmental, and general business and commercial issues. He provides legal counsel to real estate investors and developers and heavily regulated industries regarding environmental due diligence, site investigation and remediation, brownfield and voluntary cleanup programs, and compliance with federal, state, and local regulations. Following their presentation, our panelists will answer as many questions as time permits. You can submit a question anytime by using the questions tool located in the control panel on the right side of your screen. We will take a quick poll to get started. If you are unable to respond to the poll by clicking, please leave full screen mode. Where do you live and/or work? Please select one. Maryland, Mid-Atlantic outside of Maryland, United States outside of Mid-Atlantic, or outside of the United States. So it looks like we have 42% of people in the United States outside of the Mid-Atlantic region, 31% of people are from Maryland, 25% are from the Mid-Atlantic outside of Maryland, and 2% are from outside of the United States. And with that, I'll turn it over to Gary White. Welcome, Gary.
Thank you, Sylvia. I appreciate the introduction. As Sylvia said, my name is Gary White, and just want to say welcome everybody, good morning. And today I will be sharing some basic information on conducting due diligence as it relates to the federal standards for liability protections. Going through my presentation, I hope that I will be helping you demystify some of the elements of the due diligence process and making it a little bit more clear for those who are looking to do this type of work. So before we jump in, I like to do a little terminology check to kind of make sure that we're all on the same page. So in terms of when you hear the term AAI, we're talking about all appropriate inquiry. We'll get into that a little bit later, but that really relates to due diligence. That's the due diligence clause for the federal government. ESA, if you hear phase 1 and phase 2 ESA, we're talking about environmental site assessments, which are the tools in your repertoire to kind of get that all appropriate inquiry liability protection. The Comprehensive Environmental Response, Compensation and Liability Act, CERCLA, responds to the federal statute that governs hazardous substances and petroleum releases on properties. And then lastly, if you hear the term ASTM, we're talking about the American Society for Testing Materials, which really is the gold standard and the only standard that provides you with liability protection. So what is due diligence, or AAI? So the process of due diligence is the process of conducting a phase 1 environmental site assessment prior to the purchase of a site. The objective of the standard is to conduct inquiries into past uses and ownership of a property and visually inspect the property to identify conditions that would indicate or are indicative of releases and threatened releases of hazardous substances in, on, or at the site. Under CERCLA, property owners may be held strictly liable for cleaning up hazardous substances at properties that they currently either own or operate, or owned or operated in the past. The strict liability under CERCLA means that liability for environmental contamination may be assigned based solely on property ownership. So in jumps the brownfield amendments, which amended CERCLA to provide liability protections for certain landowners and potential property owners who did not cause or contribute to contamination at the property and can demonstrate compliance with specific provisions outlined in the statute. So essentially, really AAI is assessing real estate for any potential risk of environmental contamination so that you can get that liability protection. So who can perform AAI? I think this question comes up quite a few times for me, for municipalities who do not necessarily have the experience in this realm, but there are specific qualifications that are listed. You need to be an environmental professional, either have a state or tribal issued certification or license that with 3 years of full-time work experience, bachelor's degree in a relevant discipline with about 5 years of full-time relevant work experience, or 10 years of relevant full-time work experience in this field. You want to ensure that a reputable company or reputable firm with experience is conducting the due diligence for the site in question. More often than not, people confuse, people do not vet the firms that they are looking to conduct, and it really does make a difference in making sure that you have the right professionals on your team. So what specific activities does the AAI rule require, right? Or what is being done during this phase one? So during the phase one, you're looking at interviews from past or present property owners, looking at what happened on the site and kind of pulling them to get a feel for the operations of the site. You are reviewing or looking at historical sources of information, government records, looking at any sort of releases or records of release that may be on be in some of the government systems within your state or municipality. You're also looking at visual inspections, and this is where the having a great professional really makes the mark, because you're looking at the site and determining visually if there is any sort of indication of contamination or likelihood of contamination as per your visual inspection. Who does this apply to? So if you are on the call and you're looking to apply for a brownfield assessment cleanup or RLF grant, as well as a multi-purpose grant, then this applies to you. The federal standards do not allow you to use any funding for properties that have not gone through the proper process of conducting the due diligence or AAI. So that includes governmental entities, nonprofits, community organizations. In addition, any potential landowners that are looking to purchase a property, this applies to you. And then lastly, contiguous property owners, meaning any person who owns a site that's maybe adjacent to a contaminated site that is not owned by that person and demonstrates that they didn't cause, contribute, or consent to the release of a threatened or a hazardous substance on site. When should due diligence be performed? And I cannot stress this if you don't get anything from this presentation. Due diligence or AAI or your phase one should be performed every time you buy a property. You wouldn't buy a house without an inspection. Some people won't even go to a hotel without looking at the reviews. So it goes without saying that you wouldn't and shouldn't buy a property without getting a phase one prior to closing. And more specifically, your phase one should be conducted within 180 days of closing on the property. From a federal standpoint, if you're outside of those 180 days, you'll need to update certain portions of your phase one environmental report. So it's really important to time this right, but do it. Why is it important? So aside from liability protections, going in, it's nice to know what are your, to quantify and kind of get a handle on what your risks are. As you move through your phase one environmental site assessment into your phase two, and lastly your phase three, you start to demystify the possibility of contamination on site and start to quantify it. And that really helps in verifying the value of the site, because if you know you're going to have to spend $400,000 on remediation, it really then impacts your budget and your capital set. In terms of getting a brownfield grant, it also affects your grant eligibility. If you are found to have been a responsible party, you will not be eligible for any federal monies to assess, clean up, or remediate that site. And then lastly, for lenders, as an added layer of protection, it's good for they want to see that you've done your due diligence in looking at this site prior to developing it. Again, when should I be conducting due diligence? 180 days before the date of acquisition. It's important to time this correctly, because it can take about 2 months to kind of get all these things together, all the elements of the phase one together. But you want to make sure that you make a decision whether you want to buy or not within that 180 days. If that time lapses, you do have the ability to update your current phase one, but please be advised that it would need it would need to be updated if it falls outside that range of 180 days. So when it comes to conducting environmental screens, it is not a one-size-fit-all kind of situation. Over the years, I've seen different clients come and not have a phase one, but have things that have assessments that do not qualify for the liability protections under the federal statutes. So I just want to kind of talk about those really quickly. One being the ASTM transaction screen environmental site assessment. While it does bear the ASTM standard, has the ASTM name associated with it, it does not provide you with the liability protections that a phase one environmental site assessment will. So it's important to kind of look at that with a grain of salt. Over the years, lenders have come to rely on phase one as the gold standard. But as you know, the lending landscape has matured and diversified, some lenders and some sites don't bear the same level of risk as others. So there are benefits and drawbacks to this, but as a general rule, I recommend and push the phase one environmental site assessment because of its synergy with the rule. Again, the next environmental site assessment that I'd like to talk about is the Small Business Administration due diligence. Essentially, this environmental screening determines if there's elevated risk for contamination. And if that is so, then a phase one ESA is conducted. But please keep in mind that if you encounter contamination after the purchase and after you determine that a phase one was not needed, then you will not, that will not count as performing your due diligence or your all appropriate inquiry prior to buying the site. And then lastly, the HUD or NEPA environmental assessments. Essentially, again, these work as, you know, kind of an analysis of the property. Yes, they're very similar to a phase one ESA. However, they won't equate to a phase one ESA, and you would still be open to federal cases, and you wouldn't have that federal liability protection down the road if contamination is encountered after purchasing the property. So how much does it cost? I mean, this is a question that everybody has. And I kind of just provided a little bit of some numbers on the screen, but it really depends on a lot of things, namely the size of the site, how many sites you're looking at, and physical features of your property and the travel costs for your consultant. It's important to note that this is in terms of spending money or money well spent, spending this money early and upfront really helps you out in the long run. Cheaper does not mean better when it comes to performing a phase one environmental site assessment. And it really will depend on your budget, on what, you know, which consultants you can use. But I would like to say that, again, this is a pretty good range for sites that are, you know, mid-sized. Your larger sites will incur, you know, greater costs. And then lastly, where can I get more resources? I attached this resource link and compiled this for you. I think these are just some general questions that I think will help people who are looking to start this process or who are in the process of buying a site to kind of look at things from a different lens. There are many fact sheets and that simply kind of outline what resources are available to communities and to developers who are looking to do this type of work. Again, making sure that you are getting the right team and you're asking the right questions is really paramount to you saving yourself from a lot of headache down the road. And with that, I will hand it over to Jeff to talk about the state liability protections.
Gary, thank you. Thank you very much for your discussion about the federal due diligence process. Really appreciate that. Today, we'll talk about the Maryland's environmental due diligence requirements. So just so you know, there's 2 state response programs that exist within the land restoration program here at the Maryland Department of the Environment that address brownfield sites. One is the voluntary cleanup program, and the other is the state assessment remediation division. So Gary talked about this briefly. I'll reiterate because it's important. But what really isn't, what is environmental due diligence, right? So the process that evaluates the environmental condition and the risk associated with the property. This is prior to taking title. Why do we perform that? For a few reasons. Understand the liability of the property, understand the risk of contamination, that's to human health and the environment, and it's necessary to qualify for landowner liability protections. So a little background to what Gary was talking about. The Comprehensive Environmental Response Compensation and Liability Act, CERCLA, known as Superfund, right? So that's one main reason why due diligence should be performed. CERCLA was passed in 1980 with subsequent amendments. The additional amendments that were enacted helped to clarify the due diligence process and expanded liability protections. This law, Superfund law, provides EPA the authority to investigate sites where there's a suspected threat to public health or the environment caused by release of a hazardous substance. So Maryland's Hazardous Materials and Hazardous Substance Act includes the Controlled Hazardous Substance Statute and the Voluntary Cleanup Program. These laws provide the state the authority to address hazardous waste sites and defines the liability for the parties involved. So back to the all-appropriate inquiry. This is important for these programs. The Environmental Protection Agency provides standards for due diligence. This information is located in the Code of Federal Regulations, Title 40, Part 312. It outlines what is required for evaluating the previous ownership and use of a property. That's known as the all-appropriate inquiry. And it also outlines what is required to help qualify for protection from liability from those contaminants under CERCLA. Now, there's three important points I want to make here regarding the all-appropriate inquiry that Gary had touched on. So to perform, the parties that intend to qualify for liability protections, then they must perform the all-appropriate inquiry prior to taking title to the property. So that's very important. The all-appropriate inquiry is valid for 180 days from the property transaction and up to 1 year with the update. And if you plan to obtain CERCLA brownfield site characterization or remediation grants, then you must perform the all-appropriate inquiry. So those are important. I know it's redundant from what Gary said, but it's very important to remember those three points. So another way to satisfy the all-appropriate inquiry is by performing a phase 1 environmental site assessment. So EPA has determined that the ASTM phase 1 standard satisfies the all-appropriate inquiry. So of note, the currently approved phase 1 standard is the 2013 version. Now ASTM did come out with a new standard in 2021. However, EPA received adverse comments and withdrew the notice of acceptance from the Federal Register. So right now the 2013 is the standard that meets the all appropriate inquiries. So the purpose of the phase 1 is to help identify contamination or recognized environmental conditions, RECs, at the property and provide good commercial and customary practice for performing those site assessments. So it provides a uniform outline on how to investigate these commercial properties. So ASTM REC definition, just to summarize that real quick, what is defined as a REC is basically the presence of any hazardous substance or petroleum products on a property that indicate a release or a threat of a release. So Maryland state response programs, as I mentioned before, Two state brownfields response programs exist within MDE's land restoration program. The first is the voluntary cleanup program and the state assessment remediation division. Now the VCP is unique in that participants that complete the program are provided liability protections. And those are provided in determination documents known as a no further requirements determination, NFRD, or a certificate of completion, a COC. Now, an NFRD document basically just means that there was maybe no exposure risk at the property, or if there was, the current development at the property, meets the land use criteria for exposure. A COC document basically identifies that a response action was necessary. So there was risk at the property and a remedy was performed. Now, the State Assessment and Remediation Division offers technical oversight for hazardous waste only, and no liability protections are provided. Now, the participant who requests oversight from the State Assessment and Remediation Division, they could also request a site status letter for the review of the oversight that was performed. Now, that's going to be very specific to the assessments that were reviewed by the program. And it does not provide any liability protection. It just simply states that the program is not interested in looking further into the property at this point for that issue. So additional liability protection, MDE maintains a memorandum of agreement with EPA Region 3 that completed sites investigated and or remediated by the oversight of VCP are of no federal interest to EPA and to CERCLA. So completing the VCP for a property provides state and federal liability protections. Now, since the VCP provides the liability protection, we will focus on this program and the application requirements for participation. So a phase 1 environmental site assessment is required for all VCP applications. VCP policy does allow phase 1 to be valid for 1 year, but it must meet the standards outlined by ASTM International. So for example, if a phase 1 is received, it meets the ASTM standard, but the application is delayed for some reason, we'll allow that application, that phase 1, to be good for 1 year. Of course, an update will be necessary if it's beyond the 6-month point. So VCP application requirements continued. In addition to the phase 1 site assessment, a phase 2 site assessment is required upon application to the VCP, unless of course the phase 1 does not identify any wrecks. So a phase 2 basically is the intrusive investigation portion based on what wrecks were identified in the phase 1. So if your phase 1 shows the property was clean, there was no issues, no reason to believe of a release, then it's not necessary to provide a phase 2. Now, submission of a phase 2 work plan is also acceptable for the VCP. However, we need the data. We need to review the actual report that's completed to make some kind of conclusion determination with. So a phase 2 work plan will actually delay and extend the application deadlines, but it's still acceptable, and you get input from the project managers in the VCP. Okay, so beyond the level 1 and level 2 site assessments, the VCP will still want information pertaining to potential exposure routes, such as a well survey for sensitive receptors. Folks that are on wells that drink the groundwater will want to know within a half-mile radius of the property, where they exist. We'll query other regulatory programs. And these are basically out of, non-scope issues from the phase 1. So maybe asbestos, demolition of a building and there's asbestos. We'll want to identify other potential sources of contamination. And of course, you'll need to submit an application form and fee to participate in the VCP. The fee is $6,000 for new applications and $2,000 for additional applications or contiguous properties associated with the application. Now, to promote the generation of clean and renewable energy sites in Maryland, the program can waive the application fee if you have a minimum of 2 megawatt production at those facilities. So liability, we can't really talk about the liability protections unless you understand some of the definitions in the VCP. So the VCP identifies a party's responsibility and liability as a responsible party, an RP, or an inculpable party, IP, upon application to the program. So to summarize, an RP is defined as the owner or operator of a site containing a hazardous substance. Now you can find the full definition of a responsible party in the Environment article, but there are some exceptions to being defined as an RP. The innocent landowner defense. So if you did not know or had any reason to know of any hazardous waste at the property, right, that's under the circle of defense, then you would not be defined as an RP if you met those criteria. If you received the property through inheritance, or if you're a holder of a mortgage or deed of trust, as long as you did not perform any day-to-day management at the facility, then you will not be considered an RP. A person who receives IP status or a successor in interest of the property from another IP. So as long as you do not cause or contribute to the contamination, to new contamination, or exacerbate existing contamination at the property. And a government entity is not defined as an RP unless they've exhibited willful misconduct at the property or gross negligence. So I remember a site that came into the VCP. A government entity had taken title to the property through eminent domain, and there were 10 underground storage tanks full of product that remained at the property. And the new owner did not address those tanks, and over time, over the years, the tanks leaked and contamination migrated offsite, and the government entity was responsible for addressing that contamination offsite. So once again, just to remind you all the importance of performing the due diligence, right? So get a really good phase one performed, and understand, the conclusions of that phase one and anything that you may need to do to address, the issues at a property to make sure they don't get worse. It's very important. So responsible person liability protection. An RP can obtain limited liability protection by completing the VCP and receiving an NFRD or a COC. And what you'll get is the department will not bring a state enforcement action against the participant at the property. Now the participant must meet any continuing obligations at the property, such as adhering to any land use controls or engineering controls that were necessary for the evaluation. The participant is released from further liability for remediation of the property for contamination identified in the environmental assessments. So once again, important to have a good phase one and phase two assessments performed. And the entity would not be subject to a contribution action instituted by another responsible person. So legal claim requesting a financial contribution, maybe for a cleanup. Responsible person liability. So an RP maintains liability for contamination, right? So for example, an RP wants to participate in the VCP. We go through the process, they address any site contamination through exposure risk that may exist, but they would still be responsible for any contamination that migrates off the property. That would be their responsibility. Also, if they cause new contamination or if they exacerbate existing contamination. Now, the inculpable person, the IP status, IP is really a person or entity that has no prior or current ownership interest in a property at the time of application to the VCP. Has not caused or contributed to contamination at the property at the time of application, or is a successor in interest at the property acquired from another IP. IP status, now this is very important. for everyone to understand. So VCP applicants must receive a status letter from the VCP identifying them as inculpable person. This is prior to taking title to the property. Okay, there's two ways that you can receive this status letter. The first is the normal process. You receive the IP status letter upon application acceptance. And this is really towards the end of the whole process in the VCP. So we'll receive the application, review the information, maybe have comments, maybe have a phased approach of sampling. And at the end of the day, if there was really no risk to the property, an NFRD would be issued, no further requirements determination. And in that cover letter, it would identify your status as IP. So it's really towards the end. Or if you had to perform a remedy at the property, then when you receive the acceptance letter to participate in the VCP and you're requested to perform a response action, then you would be identified as IP at that point. So it's really it may take a while. It's at the end of the process, like I said. Another way that you can get it if you want it quicker, maybe you want to purchase a property, is the expedited IP status process. And if you submit an expedited IP affidavit with a fee, $2,000, then the VCP will issue you within 5 business days of receipt of that a letter with identifying you as an IP. So you'll have that. Then you could move forward and purchase a property. You could even get the IP status before you apply to the VCP. But if you do that, just please note that there's a 6-month deadline with that status letter. So if you receive your expedited IP status, then you must submit an application to the VCP within 6 months. Otherwise, that IP status will be void. Okay, so IP status only exists within the VCP. IP liability protection. So the IP obtains the same liability protections offered to the RPs, except the IP is not liable for the existing contamination, right? So no chasing the contamination off the property if it migrates. Now there are some responsibilities that an IP must still maintain, and even an RP, right? So source control of contamination to help prevent that from migrating off the property. That would be a responsibility. And then to make sure that the people that access the property are not exposed. So eliminate the exposure pathways, follow the land use controls that are set out on that property. And if a VCP participant, voluntary cleanup is by its name voluntary. So if some party wishes to withdraw from the program at any time during the process, they can do so. Now, if the department identifies the situation at the property to be a risk to human health or the environment, then we would ask the IP to secure and stabilize the property before they withdraw from the VCP. And some resources for you folks. If you want to visit our website, we have lots of information, guidance for the VCP. Also, you can download an application or even look at our mapping site to look at properties to see if there's any regulatory authority oversight for any of the properties you may be looking at. And of course, our telephone number. So thank you very much. And that concludes my presentation. I'll pass it over to Stephen.
All right, good morning, everyone. Thank you very much, Jeff, and thank you, Gary, and the Maryland Department of Planning for
Excuse me, Stephen. Can you swap your screen so we can get your full presentation? You can go up to display settings in the presentation mode and swap. It's up at the top strip all the way to the left. Show taskbar, display settings.
Yeah, let me see here.
Drop that down and swap. Yeah, it's right on your presenter view, the black. Yeah. Swap it, please.
There we go.
Perfect. Thank you.
All right. Thank you very much. Pardon the technical glitch. Okay, so thank you very much to Jeff and Gary, Maryland Department of Planning. My name is Stephen Luttrell. I'm with the law firm of Whiteford, Taylor, and Preston. And I work primarily in the environmental, clean tech, and renewable space. And Gary and Jeff have covered a lot of the how. I'm going to cover a little bit more of the why and some of the background legal considerations that you need to understand and be aware of as you're doing your diligence, pursuing all appropriate inquiries. So there's really kind of three relationships here we're going to talk about that you need to stay aware of during the whole process of investigating, purchasing, and owning and operating a property. And that's the relationship between the ownership entity and any hazardous materials that are stored on the property or maybe released to the property. And we'll think of those as sources of liability. How you're operating the property and what that operation might mean for the presence of hazardous materials or the release of hazardous materials, and how ownership entities and other entities invested in the property may change over time. And the reason you want to keep all of those present in your mind and always think of those as they relate to any environmental liabilities is that, as has been teed up by Gary and Jeff, there are many ways liability can attach, and there are other ways where you might have what we would refer to as a safe harbor from liability. And just highlighting, as Jeff had pointed out, things like making sure you apply for the VCP ahead of time and make sure you apply for that with the right entity really matter, because there are some things that you can't go back and fix later. And that may subject you to liability. So with that, let's talk about a couple of things to keep present in your mind as just broad themes when purchasing a property. One, you can have liability without fault. You can have liability with fault, but you can have liability, we'll call it without fault, for your mere purchase of the property. And that's been talked about earlier with the fact that Superfund liability is joint and several and attaches with ownership. Second, you need to understand the nuances here, as has already been mentioned, either the requirement for a phase 1 to be within 6 months prior to purchase will satisfy all appropriate inquiries. You can possibly have an older one to qualify for IP status, and so you need to make sure that you're meeting the requirements for all the applicable programs. Never assume that a phase 1 report that you have or were handed to you by somebody else is good enough. Also, never assume that just once you purchase the property and you've secured your liability protections, if applicable, that it's going to stay. And that ties into the last part, which is stay vigilant. If you have sources of liability on your property, whether it's hazardous materials storage or some activity that may bring hazardous materials onto the property that could be released, if they are released, that could invalidate any liability protections that you have. Okay. So let's talk a little bit about the basics of CERCLA and why you need to conduct all appropriate inquiries. First, because CERCLA and essentially the Maryland equivalents require you to. If you do not conduct diligence on a property before you buy it and satisfy the AAI standards, if there are any hazardous materials that have been released to the environment there such that it would cause liability, you will be liable. You've not established your right to claim any of those protections. Next, it's to protect your investment. You're committing time, energy, and resources into purchasing a property. You want to make sure that is not lost or degraded as a result of your failure to account for potential liabilities. And they can also cause issues and add transaction costs when you go to secure financing for a property. As I often tell my clients, most often a lender is going to be more restrictive and more demanding of your environmental compliance than a regulatory agency will be. So you will always have to keep them in the back of your mind, and they will always require extensive studies if there's any suspicion of environmental liabilities, and they will always require as a predicate a phase 1 report before underwriting any loan. And lastly, and let's not forget this as we discuss this, you want to be a good neighbor. You want to be good to your community. You want to be a good steward of the environment, and all of that requires being aware of how you might be impacting the property or what releases may have occurred on the property. Okay, so CERCLA basics, what it attaches to, there's really basically your status with respect to the property or what you're going to do on the property. So if you own the property that's impacted, you may be liable. If you're the operator of a property that's impacted, you may be liable. So this applies often with your ground lease situations where you may, let's say you own the property and you're going to lease it to another entity who is going to operate it in a way that may cause impacts. Both the owner and the operator could be liable. If we're talking about the removal of hazardous substances from the property, if you arrange for the removal, let's say you're a contractor for somebody who has to have waste drums removed, and you've arranged for that removal by hiring a contractor or signing manifests. If those are improperly disposed of, you could be liable. If you are accepting hazardous waste for disposal, you could become liable. And all of these relationships you can also apportion liability for these issues within transactions themselves. So I'm only talking here about just how the law works. So for instance, you might, the owner and the operator of a property may be liable for any releases by the property's operator. However, in a lease, you may bargain for certain protections in the lease where the operator is indemnifying the owner for any releases that are occurred as a result of the lessor's operation or the lessee's operation of the property. And that's really more of something you consult your lawyer with and work out with the other party. Okay, there were some initial carve-outs to liability under CERCLA. These are really, the first three were really more of your force majeure carve-outs. So acts of God, act of war, acts of third parties. In 1986, we added some additional carve-outs. There was the innocent landowner protection that Jeff already hit on, and there are, essentially kind of contiguous property owner exceptions. Okay, we get to 2002, and that begins the introduction of the bona fide prospective purchaser defense, as well as the codification of the ASTM standard as meeting the all appropriate inquiries requirement. And this standard is now both the de facto and by law requirement for those conducting environmental diligence. And before that standard, there was really kind of a wide array of what would qualify as all appropriate inquiries. Now we have the comfort of knowing that there is a codified standard. Okay, so let's talk about the bona fide prospective purchaser protection. So that requires that it's the purchaser of the property who had no relationship to the property on which any releases occurred, and is not an affiliate of an entity that caused a release to a property. That's to avoid one entity owning and operating a property, causing a release, and then trying to transfer that to an affiliate in order to gain BFPP status. In order to do this, again, you need to conduct the all appropriate inquiries, and as we'll talk about in a little bit, you need to maintain compliance with any environmental obligations after purchase, because you can lose BFPP status. There is a recent case in the Fourth Circuit where we'll get to in a minute called Ashley 2, where an entity that had qualified for BFPP status had lost it. Okay, let's talk a little bit more about what you need to do to obtain this status. So you have to conduct all appropriate inquiries, and you would otherwise qualify under the innocent landowner exemptions. And importantly, after purchasing the property, you have continuing obligations. You need to take any steps to prevent further future releases. So for instance, if you bought a property on which there were waste lagoons that were seeping into the underlying soil, you may qualify for BFPP protection. But once you take title of that property, you may be required to conduct removal or response actions related to ongoing releases. And you also have to abide by any directives from regulatory agencies. So the nuance there is that you would still be required to commit resources, both administratively and financially, to address releases that are ongoing at the property. However, if you have that BFPP status, you are not in that chain of strict and several liability from now until the end of time with other co-defendants for any release. And so that's a little bit of an issue that some folks don't understand and may come as a shock sometimes to clients, where you tell them you have BFPP protection, they think they can purchase the property and don't have any environmental liability. And while that's technically true, they may not have liability, they will have an obligation to respond to any ongoing releases and could be liable for releases that continue once they purchase the property. Okay, we've already talked a little bit about the ASTM standard, and I think Jeff and Gary have covered that well. The one thing I will tell you from my own experience is that you have to look hard at what you're being handed as a phase one report. In my experience, the phase one report and environmental liabilities in general are always something that clients somewhat want to put their head in the sand on. So I would say 1 in every 3 transactions, I'm told by my client, we have a phase 1 report, it's okay, we're good to go, and I get it, and it is from 2006 or 2017, and that's not helpful for both a practical reason and for legal reasons. For a practical reason, an older report, might not be that helpful because it's not going to capture any releases that have occurred or been found since that report was issued. Second, as alluded to by Gary, it needs to be done within 6 months of acquisition, or it's not going to qualify. Also, you need to be the user of the report in order to use it to meet statutory requirements, which means it has to be addressed to you. Now, you can get reliance letters from the party who issued it. That might cost a nominal fee, but it's something you need to do in order to be able to claim the use of that report. If you think you're safe because you've got a report that was issued in the last 6 months, but it was issued to the former owner, if there are any claims made about former releases and you have not gotten reliance on that report yourself, somebody may attack that as not providing you with the protections that you think you have. Okay, so that's the federal law in a nutshell. Going to Maryland's hazardous substance law, as Jeff had previously explained, it tracks CERCLA fairly closely, and he's already discussed the responsible person versus IP status, and that's a key distinction there. And the one thing that you really want to watch there is making sure that if you've satisfied the inculpable person status requirements, that you are also still maintaining a phase 1 that will meet federal liability carve-outs. So very often someone will obtain a phase 1, apply for IP status, and then a transaction may drag. There may be reasons why parties come in and out of the transaction. There might be delays for further diligence, particularly if there are environmental issues. And that phase 1 may become beyond the 6 months. And once it gets beyond 6 months, you either get a new one or you can have it updated for up to a year, and that will qualify. But you need to track those 2 issues and always make sure you're checking both of them as you transition between federal liability and state liability. Okay, I'll go through this quickly as Jeff's already covered on a lot of it, but there is the VCP, and while CERCLA is really the founding environmental statute, when you find yourself at the state level, it's really state liability that you're going to wind up paying attention to the most, unless you're dealing with a large release such that it's going to wind up on EPA's radar, or there's some other federal involvement in which you're going to find yourself remediating a property under the EPA's auspices as opposed to state auspices. So I noticed at the outset we have a number of folks here from outside Maryland and across the Mid-Atlantic. So something to note if you're in New Jersey is that you need to follow the New Jersey standard as well as the phase 1 standard in order to meet some of those landowner protections. And for instance, in New Jersey, you'll get a PAR, which is a preliminary assessment report. It is similar to a phase 1, but it requires more. There's a file review that's required there. It refers to areas of concern as opposed to RECs. And I point this out not to take a deep dive into New Jersey, but to point out that you cannot assume that your state's going to track exactly CERCLA. And just with the VCP related to CERCLA, you need to make sure you understand the nuances between state law and federal law wherever you are, so that you're meeting both requirements, and don't assume that one will translate to the other. Okay, I'm going to go through this part quickly again because Gary covered a lot of it already, or Jeff covered a lot of it already. Okay, now let's talk about transactional issues here with respect to environmental laws. The structure of the transaction matters, particularly on larger property acquisitions and redevelopment projects where you're going to have a number of interested parties in the property, either as a joint venture or maybe as a state and local government partnership. And in order to qualify for the VCP, you need to make sure that the entity that got IP status winds up being the entity that buys the property. Often at an early stage, when a client's beginning to look at an acquisition and conduct diligence, they might be doing it in a parent company's name and they have not formed an entity yet to pursue the transaction. Before you close, make sure that you have the right entity with status and it's the entity that's buying the property. Also, particularly with respect to the VCP, if you're going to subdivide the property, before you purchase it. And this will often happen in a redevelopment scenario where maybe the seller has the obligation to get a site plan, and then you're going to buy it after they've done that. If they've subdivided the property, you have to make sure that you've identified the property correctly in your VCP application, because you have to match the entity to the property. And sometimes as you have that final shakeout there, as things are getting finalized before a transaction closes, you might miss some of those details, or there might be a sliver of property that's not connected, and that property may fall out of what you're qualified for IP status for. And to go back to a comment at the top, if you miss that, I guarantee your lender won't. And they will find that, they will bring that to your attention, and at that point it may be too late if the transaction's closed. Also, with respect to the consultants themselves, there's a pretty wide array of prices for phase one reports. You can get one for maybe $1,500, or you can pay $4,500 for the same property from different consultants. I would urge you not to treat it as a commodity, that you get what you pay for. We'll talk a little bit about some war stories here at the end, but with complex properties with a hairy history, where there's going to be hazardous materials releases, where that securing those liability protections is important, it is worth paying for a consultant that is sophisticated, that's going to do a file review, that's going to do analysis, that's going to do more than collect those sources of information, do a site walk, check the box, and hand you a piece of paper. And that piece of paper may not have attention to those nuanced details. And they may also just find issues and not close them. As much as I've had consultants miss issues, I've also had them miss the ability to close it, where, looking at old files and seeing that a UST release that was on an environmental database but not listed as closed was actually closed when they do a file review, and they find that piece of paper that says it's closed. And finding that piece of paper may be the difference between having to do a phase two with soil and groundwater sampling that cost you $15,000 versus just a little bit extra time from your consultant to find that piece of paper to show that it's closed, to have that documented, to give to your lender, and to know and have the security in your own head that was done. Okay, and then let's talk a little bit about some case law here. As Jeff had alluded to, the timing of the VCP versus when you're having the EPA, or to qualify for EPA grants, you can have a phase one report that meets the requirements for VCP IP status. But if there's a lag in closing of the transaction, you might turn around and ask for an EPA grant and you didn't get that phase one updated within 6 months of closing, and you're not going to qualify. And this was the town of Mount Airy. It was a Maryland case that I believe was a Luttrell case, where the owner was surprised after acquisition that a grant that they had been banking on was not available to them because they did not get the phase one report before closing. And we've already covered this other piece that you're going to be required to do it. It's a small cost in the context of a transaction. Okay. Let's talk again about why it's important to pull at threads that come up here. So a deal that I was involved in Massachusetts involved the purchase of a multifamily townhouse complex outside of Boston, and the phase one report had some old mapping information that showed that there were some ponds on the property that at some point were filled in during redevelopment, and nobody knew why. The consultant kept raising this as an issue. They thought that there were some concerns given the history of industrial use around the property. We wound up eventually doing phase two testing, and the consultant went into some of the town archives to find out, what the prior uses of the properties were. We found out that it was formerly used as a tannery, and those ponds were waste lagoons, and that there was pervasive contamination in the underlying soils on the back end of the property. Not soils that were underlying any building, and not soils that any of the residents were coming necessarily into contact with, but nonetheless, it was a substantial environmental liability, and our client wound up walking away from the transaction just because of the fact that eventually that was going to have to be addressed and remediated, and that was not a liability that they were willing to sign themselves up for. Okay. Another one I was involved in, this was a New Jersey development where we had done a phase two report, or we'd done a phase two study after doing a phase one that had indicated that there were spot impacts across the property from petroleum releases. You had liability protection secured there. We had hired a contractor to clean and grub the site in connection with redevelopment. That contractor was supposed to go around these hotspots. We were going to have a remediation contractor come in to excavate. Wires got crossed somewhere on the construction management side. The earth moving contractor that was coming in to clear and grub the site cleared the top 6 inches of a multi-acre site, pushed it into a 10-foot high berm at the back property that was then commingled soil with the petroleum contaminants and a few other environmental issues, or a few other types of releases, some volatile organic compounds and other types of industrial chemicals. But where that netted out was client lost any kind of protection they could have at that point by the virtue of essentially not controlling and not documenting how those hotspots were removed and essentially pushing them across the entire property. And they were then left with a very large berm that they had to dispose of and could not reuse on site as clean fill, which cost them $7 million and essentially blew the budget on the transaction. And there were a lot of very unhappy people there. And that ties into this Fourth Circuit case we had mentioned earlier, Ashley 2, where a prospective purchaser had bought the property. They had secured BFPP status. And on that property, there were some lagoons that were releasing hazardous materials. I think they were stormwater retention basins. And the releases were not secured after purchase, and the releases continued. And that property owner was then involved in a couple of claims involving the cleanup costs and had claimed BFPP protection. And the district court in that case found that they had lost it by not addressing the releases. The landowner had also tried to make the argument that because they'd qualified for BFPP protection, that there was a lower standard that applied to them with whether or not they had to undertake removal actions or investigate or remediate. And the district court decided that it was the same standard would apply as it would to any landowner facing a release, that there was no lesser duty to somebody with BFPP protection. That was taken up to the Fourth Circuit. The Fourth Circuit agreed, and now we've got the Ashley 2 law, which is relevant to the Fourth Circuit, which includes Maryland, that says BFPP protection does not absolve you of your obligation to address an ongoing release, nor does it apply a lower standard to you than any other landowner for having that BFPP status. And with that, that's my survey of the legal landscape, and I will turn it back to Jeff.
All right. Thank you, Stephen. This is Jason Duba, Maryland Department of Planning. I just want to thank all of our presenters for their excellent presentations. And if the presenters could stay on for 10 or 15 minutes, that would give us time to ask you some of the questions we've received today. And we will stop at about 15 minutes afterwards. So throughout the webinar, we've been assembling questions for our audience, and folks, you can continue to submit questions, but we do have lots of them, and we'll get started now. And we appreciate your as presenters sticking around for a couple more minutes. So thanks, Gary and Jeff and Stephen. So I'm going to ask you the types of questions. I think I'm actually, instead of the more straightforward questions, I'm going to ask you some of the more difficult questions here that we have. So for example, let's see, I think, for example, so this is actually a more straightforward question. What is the credentialing body, if one exists, to ensure that we are hiring with a legitimate company to conduct the assessment or title of state license that should be verified with a particular state? So anybody, can you answer that particular question for us?
I think if you're looking at like New Jersey, there is an LSRP, or a licensed site remediation professional, that there is a state body that issues that credential for environmental professionals who are looking to do phase 1s, phase 2s, and phase 3s. In terms of Maryland, I don't know, Jeff, is there anything from a state perspective that you have that licenses?
Yeah, Gary, there's nothing here in the state of Maryland specifically. I mean, for the VCP, we require a phase one that's performed to the ASTM standards. So your definition of an environmental professional that you talked about in your presentation is pretty much the qualifications that are necessary to be able to perform that investigation. But yeah, you're right. Different states have different requirements for the qualifications for these environmental professionals. So look into each state, specifically.
Jeff, let me add something to that. Related to that, also be aware of whether or not the environmental professional you're hiring has an obligation to report a release if they see it. So for instance, there's not an obligation that I'm aware of in Maryland for a professional conducting a phase one report to report a release to the MDE if they find one. Now, if you're in New Jersey and you have a licensed site remediation professional conducting a phase one or a preliminary assessment report, they may have an obligation to report that to NJDEP. That's something to be aware of if you're the owner of the property conducting a phase one, and also something to be aware of if you're the buyer or the potential buyer who wants to go in and conduct their diligence. You need to be aware of that issue before you send your consultant on, as there may be reasons why the seller does not want to have an LSRP on the property. And those nuances are going to vary state by state.
Yeah, Jason, you're right. And for Maryland, there is actually a requirement to notify the oil control program of the department for a petroleum release. So that is necessary, not for hazardous waste unless you're above a reportable quantity.
Right, and thanks. And again, just pointing out the nuances there. Thanks, Jeff. You need to really be aware of who you're sending on and what the issues may be.
Yeah, thank you. Thanks for those answers. And here's another question. What if we have a partnership with a higher learning institution that supervises students to conduct site assessments? Would those students be considered environmental professionals?
So for Maryland, once again, you go back and look at the definition of what an environmental professional is for the ASTM phase one standard. Gary, you had mentioned that in your slides, maybe 3 years of practice under a senior professional, or 10 years of being in the field, and maybe, or just having a degree. So if the students, obviously they don't have a degree at that point, so they're probably not going to be considered, unless they meet the other criteria.
And I don't know if we're talking about grad students, that could be the case if they, if you're looking at grad students, but the undergrad students may not fit that environmental professional description. So it would be important to kind of clarify, whether or not they're under someone who does have that experience or whatever. But I think, yeah, when it comes to that, I would seek to kind of double check that and just make sure that, you're not violating that ASTM qualification.
And I'd add that I'd also normally want someone who's an experienced professional geologist in that state, particularly if it's a property that is going to have some investigation or remediation requirements on it. Because even at that early stage of a phase one report, before you're doing testing, you want someone who understands the nuances of what you're looking at and how different contaminants may react to different soil or groundwater or surface water media. And it's not something where you just kind of want to find the problem and then move on. You want to have context from the first day.
Thank you. Now here's a good question. What happens if a contaminant is found or suspected when you're doing an ESA that is an emerging contaminant? It's not on a specific list yet of known hazards or contaminants, things like PFAS. What happens in a situation like that? Does it vary by state, for example?
I can jump on this one. I'm actually have a presentation later tonight with Senator Elfreth about emerging contaminants in Maryland. But the emerging contaminant is a tricky issue. I don't know of any cases where that's been litigated with respect to the liability under BFPP protections or state equivalents for emerging contaminants. So for we can taking, let's say 1,4-dioxane, for instance, there's an emerging standard for that that's teed into the Safe Drinking Water Act. And, I don't think we honestly know what that means as far as cleanup liability. I would say that your protections for identifying and qualifying for BFPP status with respect to the potential for that release is going to be the same. Whether it exceeds a certain criteria, a state standard or a federal standard that's going to be compatible with the use that you intend for that property is a different question. So the fact that you're aware of a release of PFAS, PFOA, 1,4-dioxane, or other the key emerging contaminants now could qualify you for protection if you've identified that before you purchase. But if you've identified that, and then let's say you want to redevelop this into a multifamily residential development, it's hard to say at the moment whether or not you would be able to without significant remediation, because the standards for what's going to qualify as acceptable for residential versus commercial are changing by definition. The other thing to be wary of there is that you may have a certificate of completion or no further action issuance from EPA or state equivalent for a release that may involve 1,4-dioxane or PFAS or PFOA, but because those weren't involved, those weren't covered under that final remediation document at the time, you may not have protection against lawsuits or contribution claims from other parties. So it's another issue where you have to be very careful.
Thank you. I have a quick clarification on the question related to supervision of students. In that particular case, you know, the things like experiments would be done under the supervision of a degreed professor or professional. Would that change your answer at all?
Yeah, Jason, I think, you know, if the professor, you know, works in the industry, right, and practices in such a manner, but they would still need to meet the requirements of that tenure, right? So the student, I think it was 3 years under supervision. So, you know, if they were doing it for 3 years, then I guess they would meet that criteria. It's pretty explicit. So I guess, you know, just look at the timeline.
And yeah, and I think to Stephen's point as well, you really do want to rely on credentialed professionals for that kind of work. This is the establishment of your liability protection. So you do kind of want to ask those questions and kind of make sure. For me, one of the things that I do is I'm a trust but verify kind of guy. So working with, you know, if you're talking about using that program, I think it's up in New England that has that service. Maybe verifying with your federal EPA partners up in Region 1 or Region 3 or wherever you're at to kind of make sure that will suffice.
Thank you. I think there may be time for one last question. This question is from Prem Neopani. You know, you've talked generally about conducting all appropriate inquiry and due diligence for property transactions prior to acquiring the property, but how does the timeline of 180 days apply to refinancing, or is there any applicability of shelf life of a phase 1 for refinancing?
I can take that one. You'll normally be required to get a second one, or more often with refinancing, if your lender's going to require it in connection with refinancing, they will often do it themselves, and then they'll use their consultant, and then you're going to wind up paying for that consultant as part of closing fees. I will also tell you that in my experience, the lender's consultants are normally very good at finding problems, but not very good at closing problems. That's not necessarily in their best interest. That's no knock on lenders consultants, but you know, they're there to protect the lender. They're not there to explain away problems. So you're often going to need your own environmental professional to look at their findings and evaluate whether or not these are truly issues that need to be addressed, or if these are just issues that, you know, could be addressed through doing further research into the regulatory record, or looking at past uses of the property. And why that is important, and I'll stress this, and I imagine, I don't know how Jeff's going to feel about this, but I'm sure Gary will agree with me, is that you want to avoid subsurface testing at all costs. I will tell you that drilling a hole in the ground and taking an environmental sample, I'll use a sports metaphor here, is like throwing a pass in football. There are 3 things that can happen, and 2 of them are not good for you. and you don't want to be in that position. You're either going to find something that is clearly an exceedance, you're going to find something that's inconclusive, and if you're very lucky, you will find no problem whatsoever. But here in the Mid-Atlantic, with a history of industrial use, particularly in areas where it's more profitable to buy and redevelop property, the chances of you not finding something are low. And so you want to be very careful about whether or not you are taking any samples.
Yeah, Stephen, just to follow up with you real quick on that one. I agree with you. It's very unpredictable when you collect samples, for sampling. But I will say that, from the VCP perspective, if, somebody comes into the program, we're relying on the site assessment, right? So the better your phase 2 data is, or the assessment, you're going to be protected from what was identified, right? So if it's not identified, you're not protected for it.
Yeah, and I would agree with Jeff, and by no means want to undercut that. You definitely want to go in with as much information about the property as you can. Where it becomes tricky is if you've now owned the property for 2 or 3 years, and somebody's telling you to go take samples for something else, just because they're very risk averse. That's where you need to be careful. But certainly at the outset, you want to know as much as possible.
Thank you guys for those illuminating responses. I think that was really helpful for everyone. We just wanted to give you each an opportunity to end with a final thought. We would start with Stephen and then go to Jeff and then Gary. So Stephen, if you have any final thought that you'd like to share.
Yeah, I would just stress to the audience here that Jeff and Gary and I do not work together and have never done a project together, but you heard a lot of the same themes from us over and over and over again. And I would say if you have a professional in the environmental industry, somebody from the regulatory side, and a lawyer all telling you that you need to do something, that is probably a good indication that you should do it. The chances that all three of us are wrong are pretty low. So look into the property, pay attention to your liability issues, and never make an assumption, and consult your professionals whenever you think that there might be a chance for a risk.
Thank you, Stephen. So we'll go to Jeff next. Jeff, if you have any final thought.
Yeah, sure. Communication is huge. As Stephen talked about, some issues with contractors, moving material around without, having the right communication with the owner or the consultants, that can cause big problems. For the VCP, you can, an entity can do a pre-application meeting with us, and but it's always a good idea to communicate with all the parties. If you can do it in advance, that's even better, to allow some flexibility in the process. But communication.
Thank you, Jeff. Gary, you want to close us out with another final thought?
Yes, I think in my experience, having your cross-functional partners and just creating your team is really paramount to the project success early on. So getting, your state partners together, your state for your prospective states, your federal partners engaged, the correct consultants engaged, and having those meetings earlier on to kind of determine what are the steps that need to happen really do help pull everything together and make you allow you to be a manager that will be looking at things from a larger perspective. So that's one thing that I would say, and just leverage whatever resource you can, whether it's the brownfields program that Maryland offers, or the TAB program, or whatever your state offers that will allow you to get some free assistance. I think getting those partners engaged earlier on is really key in your understanding and the project success.
Thank you, Gary. So we would like to offer a very large thank you to Gary, Jeff, and Stephen for a great presentation, to everyone who attended today, and to John Coleman, our communications and technology expert, who helps to make this all happen. The complete recording of today's webinar will be posted on the Maryland Department of Planning's website. Also, for those who have requested one, all attendees will receive an email that will contain a link to a personalized certificate of participation. Please look for this follow-up email if you need the certificate to claim other continuing education credits. When you exit from today's webinar, you'll be asked to participate in a short evaluation. Please take a few moments to provide feedback so we can continue to improve the webinar experience for you. Keep an eye on your email inbox for details on webinars in this series, including the new ASTM Phase 1 standard, the nuts and bolts, at 1 p.m. Eastern tomorrow, June 16th, and Revitalization and Redevelopment, Advancing Local Projects Through Tools and Programs at 1 p.m. Eastern on June 22nd. Have a great day.